alumnus. And whereas the legislature wishes to recognize the substantial time and energy that Chief Justice Gilbertson has devoted outside the courtroom to supporting the legal system and the citizens of the state of South Dakota, the Chief Justice has served on the Judicial Bar Liaison Committee of the State Bar and is a court counselor for South Dakota Boys State since 1995. Chief Justice Gilbertson has held many positions with the Conference of Chief Justices, including serving as president of the conference for the 2015-16 term. He's the third longest tenured member in the United States or its territories of the Conference of Chief Justices, is the longest tenured Chief Justice in the state's history. Chief Justice Gilbertson has gone above and beyond the requirements of his position. And whereas Chief Justice Gilbertson will be giving his 19th and final State of the Judiciary message to the legislature today, January 15, 2020, it's fitting at this time that the distinguished career of Chief Justice Gilbertson be recognized by the entirety of the legislature. Now, therefore, be it commemorated by the 95th legislature of the state of South Dakota that the legislature honors and commends Chief Justice David Gilbertson for his dedicated service to his community and state and extends its best wishes for continued health and happiness. Congratulations.
Thank you. Thank you. Appreciate it. Thank you for that recognition and honor. I'm not sure I deserve it. You maybe cleaned me up a little better than I deserve, but it's much appreciated. I would also like to thank Bishop Zelmer for the invocation today. This is my 19th year, as it's been said. 18 of those 19 years, Bishop David Zelmer did the invocation. The only year he missed, he had a good excuse. He was in Africa on a mission trip. So, well done, thou good and faithful servant. Governor Noem, Lieutenant Governor Roden, Speaker Haugard, members of the legislature, constitutional officers, my fellow justices, judges, unified judicial system employees, and all citizens of the state of South Dakota. This is the 19th year I've been privileged as your Chief Justice to deliver the State of the Judiciary message. There's several reasons that I do so. It allows this legislature, the bar, and the taxpaying public to know what's going on in the unified judicial system from the person who is ultimately responsible for its overall operation, the Chief Justice. As President Harry Truman once observed, the buck stops here. This is also an opportunity for me to identify problems facing the state's legal system and propose how to address them. If you look back over the last 19 years, that is a consistent theme of my messages. They are not sugar-coated. You get the bad news along with the good news. Some are clearly not pleasant bedtime stories. Many programs that have been instituted during the past 2 decades deal with people experiencing problems. Governor William Janklow was fond of saying that government should do for people only what they cannot do for themselves. Our many programs focus on those groups: victims of crime, the abused elderly and children, the mentally ill, those addicted to drugs and alcohol, and those denied reasonable access to rural legal services. I've spent much time talking about the UJS problem-solving courts and alternative sentencing programs, drug courts, DUI courts, veterans treatment courts, mental health courts, and the HOPE program. We all agree that people who commit crimes should be held accountable and the public safety protected. However, we also need to be realistic enough to deal with the underlying cause of what got them into the criminal justice system in the first place. This requires more common sense than profound knowledge. To ignore the underlying cause is simply to guarantee that those people will return again and again to the criminal justice system, a revolving door until they either die or are cured. Under these circumstances, cures are not all that frequent. Our alternative sentencing programs are not a get-out-of-jail-free card. They are not meant for people who commit violent felonies, predatory sex offenders, or those who could make a conscious choice to be career criminals. We have prisons for those folks. On the day I became a judge back in 1986, a wise, seasoned judge advised me that the purpose of a court system is not to fill the jails, it's to keep the peace. Our evolving alternative programs are an attempt to fulfill his observation. 11 years ago, our alternative programs were non-existent. Today, we now have 19 of those programs that cover significant portions of South Dakota. 516 South Dakotans have successfully graduated from those programs. The condition of the judicial services offered to the citizens of South Dakota and those who use our court system is excellent. Recently, a Harris poll was taken on the status of the state court systems in all 50 states. Those polled actually use our courts and the courts of other states. I was delighted to learn that of the 50 states, South Dakota placed at the very top. We were #1 overall. However, there are storm clouds on the horizon that I will talk about later in my message. Those of you who serve or who have served in this legislature may wonder from time to time if the bills you pass and become law ultimately do any good. A major portion of my message to you today is to detail how these judicial laws have succeeded in improving the lives of South Dakotans. In the past year, there's been significant public and legislative discussion about Senate Bill 70. A major portion of that discussion concerned the merits of presumptive probation, as well as the fiscal impact of alternatives to it. When it passed in 2013, Senate Bill 70 overhauled the state's adult criminal justice system. At that point, the then existing prison system was overloaded with nonviolent offenders. The state had two options: either build and staff an additional women's prison and men's prison, or try the route adopted by the legislature that became Senate Bill 70. The drafters of Senate Bill 70 realized that policy changes would need to be reviewed as the times and events change. Clearly, no one at that point could foresee the explosion of drugs, especially meth and opioids. Realizing that the law should not remain static, Senate Bill 70 provided for an oversight council that made up of various participants in the criminal justice system. It provided a vehicle to review a portion of, or all of, the Senate Bill 70 statutes. It also provided a vehicle to review the costs of alternatives to the present system. That council sunsetted after 5 years. That does not mean, however, that it's not important to continue to re-examine the policy changes that Senate Bill 70 implemented and the interplay of its provisions to address public safety, produce better outcomes for those involved in the criminal justice system, and wisely spend the taxpayers' dollars that support the criminal justice system. The UJS stands ready to continue this examination. Last year, there was also significant discussion about Senate Bill 73, which overhauled the then existing juvenile system. Under the system that existed prior to its enactment in 2015, South Dakota led all 50 states in the percentage of juveniles who were incarcerated. Obviously, that is not something to be proud of. Moreover, placements were costing the state a great deal of money, and they were rising. As with the adult Senate Bill 70, its counterpart, Senate Bill 73, for juveniles provided for an oversight council. It still functions and can review a portion of, or all of, the laws on juvenile delinquency and report its findings to the legislature. It can also provide an estimate of costs for alternatives and compare them to the costs of the current system. As options are studied, one thing is clear. We can no longer return to the brick-and-mortar juvenile institutions that the state possessed and operated in the 1950s and the 1960s. They no longer exist. At its core, the goal of Senate Bill 73 is to provide protection for the public and corrective action for the juvenile and his or her family. As my friend Clarence once said, all kids are good kids at heart. The trick is to keep them alive. A few years ago, I informed you that a new wave of evil had descended upon our citizens. That evil was the increased addiction to drug usage. That evil continues to stalk our land and decimate and devour all too many of our citizens. South Dakota's drug courts and DUI courts assist us in ridding our population of the curse of drug and alcohol addiction. We aggressively promote these successful alternatives to continued addiction. These programs save lives that would otherwise be lost. They also provide substantial savings to the taxpayer. A year in the penitentiary costs about $22,000 a year per person. A year in a drug court or a DUI court costs a fraction of that, or about $8,000 a year. That cost has remained constant over the previous years. While it is a bargain, it's not free. To maintain the high-quality counseling and treatment services that are imperative to successful treatment, I'm requesting an additional $650,000. It will allow the statewide network of drug courts and alcohol courts to continue to work successfully because of the well-trained and dedicated people who comprise the treatment teams for each one of our courts. Sending someone with an addiction to a penitentiary or a jail that provides no treatment is like sending someone there with cancer and expecting them to be released cancer-free. Addiction hijacks the brain as well as the body. A particular concern to me is the literal explosion of the number of females convicted of drug offenses. When I was a circuit judge in the late 1980s, there were only 32 beds in the state's women's prison, and it was never full. Today, it has unfortunately passed the 557-bed mark. The curse of a drug addiction has negative family consequences also. National studies show that up to 80% of the children who have a parent in prison will someday also end up in prison. The revolving prison door carries with it generational consequences. Drug addicts are so concerned about feeding their addiction that they ignore the emotional and physical needs of the children in their household. Medical researchers tell us that when a child is born, the vast majority of what that child learns occurs in the first 3 years of its life. Brain scans of children evidence a children's mental development during that time period. For children of drug addicts, there is no development because they are ignored. A brain scan of a 3-year-old child of drug-addicted parents compares with an aged victim in the advanced stages of Alzheimer's disease. Both scans are basically empty. For the children, this damage is irreversible and cannot be made up through medical or remedial means. They are cursed with going through life robbed of a chance of leading a normal life. They and society are the ultimate losers. When the drug court pilot program began in the Northern Black Hills in 2008, we never dreamed that the evolution of society would present such monumental problems. The drug problems in those days were considered manageable. Now it is everywhere, and despite our best efforts, we once again are playing catch-up. For example, the number of adults arrested for drug crimes in South Dakota climbed from 2,778 in 2008 to over 9,000 in 2018. That's an increase of 227% in just 10 years. In 2018, we served 594 participants in our drug courts, veterans courts, and DUI courts, which was up from 519 people the year before. 135 participants have already graduated from these fine programs. Well, what's their future on graduation? Of those who have been out of the programs for 3 years or more, 82% of the graduates do not reoffend. Only 18% do reoffend. That is substantially higher as a success rate than the 43% success rate for people paroled from the penitentiary. Currently, our programs are limited by dosage and type of treatment services available on an outpatient basis. When inpatient treatment services are warranted, they are difficult to access for the participant due to the long waiting periods for inpatient treatment. The drug court has no such inpatient option. It cannot accept those unfortunate folks. Housing for drug offenders is limited or entirely unavailable. This creates a situation where it is impossible for the participant to be successful while trying to balance paying rent with attending numerous hours of required treatment services. We cannot expect those with addictions to work full-time and move successfully through the drug court program if they live under a bridge or in a cardboard box. The reality is that they go to the penitentiary or the funeral home because we cannot take them into our programs. I think it's time to develop a concept that will incorporate a residential housing component into our program. It makes little sense to treat the addicted who have a home and, like the priest and the Levite in the parable of the Good Samaritan, pass by on the other side of the road and ignore the person laying in the ditch. Former Chief Justice Warren Burger noted, "Concepts of justice must have hands and feet." In 2017, this legislature passed a broad-based legislation to speed up and improve the treatment of criminal defendants who cannot proceed in the criminal justice system because they need to be evaluated by mental health professionals to determine if they are competent to assist their defense attorneys and enter a plea to the criminal charge. This legislation reduced the waiting time for these competency evaluations from a 4 to 6 months range now to an average of just 37 days. It expanded the definition of who's authorized to do competency evaluations and increased the number of available competency evaluators from 6 to 31. It goes a long way to ensure statewide coverage. No longer do all roads lead to Yankton and the Human Services Center. For the first time, law enforcement stakeholders across the criminal justice spectrum have completed a significant amount of mental health training. This legislation did not exist in South Dakota prior to 2017. When I addressed you last year, the mental health court in Rapid City had just become fully operational after a 6-month period of selecting and training its staff. Now, with the year of operation, I'm happy to report it's doing well. The program has grown in its first year. It now serves 13 clients. It promises to provide significant mental health services to defendants whose underlying reason for becoming enmeshed in the criminal justice system is mental illness. To treat them instead of incarcerating them for lengthy periods of time is more effective, reduces costs, and reduces the likelihood of retreat. Excuse me. It reduces also the repeat trips into the criminal justice system. Last year, this legislature also funded the creation of a mental health court in the Minnehaha County area. The need for the mental health court there was great. In just 5 months in 2018, 515 people, or 14% of the prisoners screened at intake in the Minnehaha County Jail, indicated that they may suffer from mental illness. The appropriate 6-month training period is now completed. This Minnehaha County Mental Health Court will follow in the footsteps of the successful Rapid City Court. It became operational January 1 of this year, and I'm pleased to report that their first court hearing is this afternoon. The UJS is exploring the concept of incorporating mental telehealth services into the judicial system. We have discussed establishing mental telehealth services with law enforcement entities that are not large enough to have direct local access to these kinds of services. When I discussed this idea with Walter Panzerer, the trustee of the Helmsley Charitable Trust, we thought it would be worthwhile to see if this concept could be expanded to provide mental telehealth services to others in the criminal justice system. Governor Nome has agreed to also participate in a study of this proposal. It could help criminal defense attorneys dealing with clients. It could assist judges in providing better judicial proceedings and sentencings. It could provide court service officers with the tools to better supervise and rehabilitate probationers with mental health issues. It could, in limited cases, also assist prosecutors. This is extremely important to everybody, as more people are placed on probation in this state than sent to the penitentiaries. Beyond the boundaries of the criminal justice system, I have also participated in discussions with leaders of legislative committees about the potential of the telehealth system for mental health needs outside of the criminal justice system. The potential uses of a telehealth system, especially for the rural portions of our state, in my opinion, offers great potential. The Veterans Treatment Court concept continues to expand and grow. We now have active veteran treatment courts in Minnehaha County, Pennington County, and Cottington County. All programs are under the supervision of a judge who themselves is also a veteran and can relate to the problems that veterans face. We have been assisted by the services of the Veterans Administration. This has allowed us access to inpatient VA treatment where appropriate. Therefore, the Veterans Court treatments stand alone among all our problem-solving courts because they offer inpatient services. At the end of the horrific Civil War, President Lincoln commented, "Thank God I have lived to see this day. It seems to me that I have been dreaming a horrid dream for 4 years, and now that nightmare is over." We hope veterans who complete our program will be able to put their demons behind them and say the same. Drugs are an increasing problem in the rural areas as well as in the urban areas of our state. Unfortunately, in the rural areas, the mental health and addiction services we use in our drug courts and DUI courts are not available. Instead, we have instituted a HOPE program. This is a specialized form of intensive probation. As a condition of this probation, participants follow the requirements of HOPE probation under the supervision of a specially trained court service officer. The program focuses on drug offenders with a high risk to reoffend. Random frequent drug testing is a key component of HOPE. There are swift, certain, and proportional sanctions with a weekend in jail for noncompliance with probation conditions or failing a drug test. HOPE started in 2014, and it's now active in 14 counties. As of July 1 of 2019, 373 individuals have participated in the program. 106 currently do so. 138 have successfully completed the program. But for this fine program, many of these participants would be in the penitentiary or would be headed there because they reoffended. Presiding Judge Scott Myron, the creative force behind this program, estimates that 80% of the people who complete the HOPE program would have failed conventional probation because of continued drug use. In 2007, this legislature authorized a statewide implementation of the 24/7 program. As a condition of bond, those who are facing certain alcohol-related offenses, such as a DUI, are required to 1, abstain from the consumption of alcohol, 2, stay out of places where it's sold or served, and 3, report to the local sheriff's office twice every day to submit to a breath test. Failing that test results in immediate incarceration for 24 hours. Failing to appear for the test results in an immediate issuance of an arrest warrant. Throughout the history of the program, over 35,000 South Dakotans have been tested. The failure rate is only an astonishing 1%. The other 99% are in compliance or have been with the abstinence requirement during their time in the program. The 24/7 program has produced at least 2 positive long-term results. Felony DUI convictions have dropped from 1,348 in 2007 to 551 in 2019, a reduction of 60%. From 2000 to 2004, an average of 83 lives were lost each year annually to alcohol-related traffic fatalities. From 2014 to 2018, the number dropped to 51 a year, a reduction of 40%. The 24/7 program played a significant factor in this decline. The 24/7 program has been so successful that it has been copied by other states and is now studied in other countries. A few years ago, at my request, this legislature passed a comprehensive program to protect our senior citizens from physical abuse, mental abuse, and financial abuse. These statutes are providing their intended results. Moreover, a special assistant attorney general and a full-time investigator provide aggressive enforcement and protection for vulnerable seniors. Statewide enforcement under the supervision of the Attorney General provides this statewide protection. Despite the old saying that you cannot legislate morality, you can and did legislate protection for South Dakota's senior citizens. Every state in the country lacks attorneys in rural areas. The South Dakota Rural Attorney Program continues to be the gold standard for all 50 states. The Rural Attorney Program expands our ability to have rural citizens access legal services in their home counties and towns. We currently have contracts with 25 rural counties in South Dakota to assist them in placing an attorney in their county. The results are impressive considering that 5 years ago, this program did not exist. Last year, the very first group of 5 attorneys accepted into the program successfully completed their 5-year contractual commitment to the program. 4 of the 5 have chosen to remain in their rural locale, thus achieving a long-term successful result for local access to legal services in those areas. 2 years ago, the law expanded the benefit to smaller municipalities with a population of 3,500 or less. The City of Elk Point, in partnership with Union County, became our first municipal contract. The City of Sisseton, in partnership with Roberts County, became the second municipal contract. In 2019, this legislature made the program permanent. Now, when an attorney completes that 5-year contractual obligation, that open slot is replaced with another lawyer placed in another county or town. That ensures the program will continue to provide attorneys where needed instead of ending when it reached its original 32 allocated slots. All trends continue to be positive. Chief among them is not one attorney who has gone into this program later left a rural practice due to a lack of available legal work. The need is there, and the need is being met. We are obtaining quality participants to go into the South Dakota Rural Attorney Program. The county, the municipality, the attorney, and the public are beneficiaries. This is taxpayer money being well invested. It will pay long-term benefits for the participant counties, municipalities, and the state as a whole. It helps the infrastructure of these rural counties expand and grow, rather than wither away and become uninhabited with only remnants of courthouses in what was once a thriving rural society. Several years ago, when there was the threat of a pandemic looming, I sought and obtained from this legislature the legal authority to react promptly to natural or man-made disasters that interfere with the administration of South Dakota's judicial system. We came very close to invoking these provisions during the floods along the Missouri River in 2011, but in the end, the courthouses that were threatened at that time were able to remain open. Unfortunately, the city of Burke was devastated by a tornado last August. It demolished portions of the school that were only 200 feet away from the Gregory County Courthouse. The courthouse sustained damages to its doors and windows, and we were unsure when electrical power could be restored and whether our IT systems would continue to function. Faced with these uncertainties, the Supreme Court invoked its emergency judicial power at the request of the presiding judge. We temporarily moved court operations from Gregory County to neighboring Tripp County to provide continued access to the public. We were fortunate in that it turned out that the damage to the Gregory County Courthouse was not as extensive as it could have been. In a matter of days, I personally inspected the courthouse. I conferred with the Gregory County Commission and the presiding judge, and then obtained Supreme Court authorization to reopen court services in Gregory County. As for the experience, one newspaper reporter quipped, "Out of the whirlwind, the Lord answered Job's plea for justice, say the scriptures." This was a valuable experience for the Supreme Court. We experienced how to implement emergency judicial power. Future events may present us with a more serious and long-term challenge. Over the past decade, there has been a steady decline in the number of applicants for vacant judicial circuit judge positions. In a perfect world, the governor, who fills most judicial vacancies, would have an impressive number of highly qualified candidates to choose from. In election years, a similar group of highly qualified candidates would be available for voters to consider. Well, why is this important? In 1993, the South Dakota Supreme Court, in a case of Cummings versus Mickelson, observed, "The power which the people of this state have entrusted to a circuit judge affects the people's lives, welfare, and property to no small extent." Circuit judges exercise this substantial power for extended periods of time, sometimes well over 25 years. In recent years, judicial salaries in South Dakota have fallen significantly behind comparable income of South Dakota attorneys in private practice, and have also fallen significantly behind the judicial salaries in our neighboring states. Thus, it's not surprising that the number of applications filed with the Judicial Qualifications Commission for judicial vacancies have fallen substantially. Would you want you or your family's life, property, or liberty in the hands of somebody who barely made it through law school, finally passed the bar after flunking it 3 times, and has not kept abreast of the many changes in the law? That sorry situation cannot be allowed to exist now, nor should it in the future. We need to retain judicial excellence that has resulted in the Harris poll ranking South Dakota with the best legal system of any state in the nation. Court services, commonly known as probation to most of us, is a form of judicial supervision for adult convicted felons who are not sentenced to penal institutions. It quietly functions in an efficient manner. There are more people on felony adult probation in South Dakota than in the penitentiaries, the county jails, drug and alcohol courts, all combined. Today it totals over 9,400 people under our supervision. Not everybody qualifies for probation, nor should they. Dangerous felons, career criminals, predatory sex offenders, and the like belong in the penitentiary. Those seriously addicted to drugs and alcohol who have committed offenses other than those I just referenced belong in our drug courts or DUI courts or other treatment courts. In 2017, this legislature adopted a comprehensive program to deal with the mental health of those who come into the criminal justice system. There have been many benefits. Court Services has adopted a standard intake screening to determine if symptoms of mental illness are present when a person comes into our probation system. Last year, 1,921 probation mental health screens were completed on people placed on probation. 1/4 of those screened indicated a referral should be made for a mental health assessment. Mental health screens will enhance the quality of court services supervision, increase the likelihood of successful probation, and reduce the likelihood of repeat offenses. Improvement of our court services program is a plus, not only because of the number of people we deal with, but because of the cost factor. Probation costs the taxpayers about $3 a day per person. I think county jail rates are now about $80 a day, and as I told you, it's about $22,000 a year to keep somebody in the penitentiary. A quality court service program, therefore, benefits everybody in the long run. In the face of substantial increases in the number of people placed on felony probation in recent years, the number of court service officers tasked with their supervision has remained basically stagnant. As I've told you before, the rubber band can only stretch so far before it breaks, and we are at that point. Thus, I sought 7 additional court service officers to deal with this situation. 3 would be stationed in the Sioux Falls, southeast South Dakota area, and 3 in the Rapid City, Black Hills area, and 1 in the Watertown area. If funding permits, it would really take 20 additional court service officers to fully address this current dire shortage. Traditionally, the passage rate of the South Dakota bar exam for first-time test takers who graduated from the University of South Dakota School of Law was expected to be in the 80 to 90% range. Those takers from out of state were also more likely to pass than not. Several years ago, that passage rate radically declined for both in-state and out-of-state test takers. This decline was not unique to South Dakota. It was a nationwide problem. Much has been written about the causes of the decline, and there's been more than a little finger pointing. No single cause has been identified. It was likely a combination of a number of factors. The University of South Dakota School of Law made improvements in its teaching and preparation for this crucial test. Members of the bar and the public contributed significantly to fund scholarships to encourage the best students to stay in South Dakota for their legal education. The Supreme Court made modest modifications in testing procedures and scores required for passage. One thing did not change. The South Dakota Board of Bar Examiners remains stable in its membership. Several board members remain from the previous glory days of the 90% passage rates. Through these ups and downs, the Board of Bar Examiners continues to function as gatekeepers by recommending to the Supreme Court only those people who can pass this rigorous exam and possess good moral character to be allowed to exercise the powers granted to an attorney. As I told you last year, the improvement in the bar exam results for the USD School of Law graduates who were first-time test takers was nothing short of stunning. In July of 2016, the passage rate had fallen to 52%, or 59%. A year later, it fell even worse to 52%. However, in 2018, 1 year later, it rebounded to a passage rate of 82%, a 30% improvement in just 1 year. And this past year, it was 81%. So this hopefully establishes a long-term positive trend rather than a one-year aberration. Early in my tenure as Chief Justice, it became clear to me that a significant number of South Dakota attorneys were not proficient in the complex area of Indian law that combines federal law, tribal law, and state law. Therefore, in 2007, the South Dakota Supreme Court passed a rule that required testing on Indian law as part of the South Dakota bar exam. My theory was that an attorney who learns Indian law and passed the bar exam would retain that knowledge of Indian law when they practiced law, which would benefit clients seeking that professional legal assistance. Since its enactment, the administration of this portion of the bar exam, as well as the entire exam, has been expertly overseen by our Board of Bar Examiners. Many states have opted to go to a national standardized bar exam. Were South Dakota to join this movement, we would no longer be able to include Indian law on our bar exam. That happened in 2 other states that previously tested on Indian law on their bar exam. It is the South Dakota Supreme Court's highest priority to retain the Indian law question and let other states enter into standardized testing if they so choose. While South Dakota remains the lone state to annually test on the subject of Indian law, knowledge of this area is essential for lawyers who practice in South Dakota. It recognizes a significant portion of our citizens and their tribal government. Cooperation between the tribes and the state must be more than mere words. It must also be deeds. As Benjamin Franklin observed, well done is better than well said. This important program has achieved its intended results. It is an unqualified success. Prior to 2001, if you wanted to hear a South Dakota Supreme Court oral argument, you had one option: drive to Pierre, no matter the weather, and attend in person, and hope that you were one of the lucky 27 who had access to the limited public seating in our courtroom. If you wanted a copy of a Supreme Court opinion, you could purchase it for a fee from a law book company and wait 8 weeks for its publication. In September of 2001, television and still cameras were allowed in the Supreme Court oral arguments for the first time since statehood. Not long after that, the court installed internet access to live oral arguments on the Supreme Court's website. This was a blizzard-proof improvement. It also improved press coverage. Any member of the press can sit in his or her press room and listen to the arguments unfold rather than trying to convince an editor that the drive to Pierre is worth the time and expense. Moreover, all oral arguments back to 2001 are archived on the Supreme Court's website, and current oral arguments are posted within 24 hours of the argument. If you learn of a decision that interests you, you can listen to the oral argument to expand your understanding of the decision. The court's written opinions are posted on the court's website the same day that they are issued, a Thursday. Thus, the press and the public have instant access to Supreme Court decisions. At the circuit court level, limited access to trials and other proceedings is now also available. Both audio and video coverage are authorized when the attorneys and the judge consent. The judge, on his or her own discretion, may also allow audio coverage. In 2004, the UJS established an interface television system. This allows for transmission of a two-way closed television system between every courthouse in South Dakota. It's used for bond hearings, pretrial hearings, witness participation, depositions, and meetings of UJS personnel. Once again, it's blizzard-proof. The UJS is currently engaged in a pilot project to improve access to our courts. This is possible because we adopted an electronic document system known as Odyssey several years ago. Beginning July 1 of 2019, attorneys who are not officially involved with a case may still review any case file electronically. Ultimately, we hope to provide the same access to the public. However, this presents implementation problems. People's private information must be protected and redacted when necessary. For example, several decades ago, divorce filings were indexed under the Social Security number of the husband or wife. Before these files can be made open for public inspection, information such as Social Security numbers, bank account numbers, and ID tax numbers must be redacted. Public access to our court records should not inadvertently assist identity theft. The Supreme Court and the circuit courts exist to resolve the public's legal disputes. The Supreme Court has made major strides in allowing the public to learn how the courts resolve these disputes. The current system works so well that it may come as a surprise to some that it's not always been that way. Last April, Governor Noem appointed Circuit Judge Patricia Devaney to fill the vacancy on the South Dakota Supreme Court caused by the unexpected death of Justice Stephen Zinner. Justice Devaney's experience and temperament render her superbly qualified to be the 52nd Justice of the Supreme Court. Justice Devaney served in the office of the South Dakota Attorney General from 1993 to 2012. There she obtained broad-based experience in trial litigation and appellate work. Her work brought her into contact with major civil and criminal investigations. Since 2012, she has served as a circuit judge in the 6th Judicial Circuit, handling major civil and criminal cases. This career path provides Justice Devaney with an extensive background in all areas of the law, the courts, and appellate jurisdiction. She is an exceptional addition to our Supreme Court. Please help me welcome Justice Patricia Devaney. Okay. Well, what's the future of South Dakota's judicial system? It's difficult to plan for the future if you do not learn from the past. The philosopher Santayana observed that those who ignore the lessons of history are doomed to repeat them. Looking towards the future, I agree with the classic statement that the only thing necessary for evil to triumph is for good people to do nothing. Even with a thorough knowledge of the past, planning for the future is not easy. I recently reviewed my initial 2002 State of the Judiciary message to this legislature. I noticed that not one of the topics I talk about today was discussed in that original 2002 message. It clearly was another time. The youth of our state are its future. Today we see helpless children who are the victims of abuse and neglect. The numbers are sadly increasing. Likewise, all too many of our youth are being crippled by addiction to various kinds of illegal drugs. Although we are a state of many cultures, the common thread of our heritage is the long-standing recognition of caring for the needs of our children and our youth. The biblical admonition that little children are to be protected rather than to be treated as a piece of family property to use or abuse is a hallmark of our country's Judeo-Christian heritage that arrived on our shores with the Pilgrims and continues to this day. Similar traditions of concern and care for children and our youth come from our state's Native American population. It has received continual legal recognition from our earliest statutes and has evolved with time. While we have been characterized today as a throwaway society, it can in no way include indifference to the plight of children or the youth in need. That is not to say, however, that we are raising a generation of drug addicts in South Dakota. For 25 years, I've been a counselor at American Legion Boys State, teaching our brightest and best high school students how the Supreme Court functions to resolve people's legal disputes. Every year, I come away from this event highly impressed with the caliber of our students that I come into contact with. The same can be said about the fine reports I'm receiving from Girls State. The face of the South Dakota judiciary has also evolved. In my opinion, the biggest change that's taken place in the state courts of South Dakota is that they have shifted their focus from being reactive institutions to being proactive in many respects. Early on in my service as your Chief Justice, I commented to you that the South Dakota judiciary should mirror the citizens it serves. At that point, South Dakota's judicial system was overwhelmingly male. Only 6 women were on the circuit bench and none on the South Dakota Supreme Court. Today, 18 female circuit judges out of a total of 44 hold office, and 2 of our 5 Supreme Court justices are females. We have 7 judicial circuits in South Dakota that are overseen by a presiding judge. Of those 7 presiding judges, 3 are women. The situation has improved so much that today appointment of a woman to the bench is considered part of a norm and not an exceptional event. As far as the future, there's a solid distinction between gazing wistfully into a crystal ball and planning for the future. This differentiation requires no profound knowledge. Through my lifetime, I've tried to follow the motto of the Boy Scouts, be prepared. While planning for the future is essential, you have to maintain enough flexibility so when the unexpected comes, and it will come, you are able to adjust to meet it and not be overwhelmed by it. If you follow the quip of Benjamin Franklin that the only 2 things in the future that are certain are death and taxes, that does leave a lot of area for the unexpected. The best we can do is prepare to the optimum of our abilities. In so doing, we are guided by the Constitution, statutes, and the goal of maintaining a peaceful resolution of citizens' disputes. The people within the judicial system come and go, but the fundamental basics remain the same. We do not want to be a legal dinosaur lumbering off into oblivion. The book of Ecclesiastes declares, to everything there is a season. As I mentioned before, this is my 19th State of the Judiciary message. It is also my final message since mandatory retirement looms. As such, a few parting comments may be appropriate. My father was a minister, and my mother was an Army combat surgical nurse during World War II. On the day I became a Supreme Court Justice in 1995, one wit observed, "The Gilbertsons will save you one way or another, whether you want it or not." During my time on the Supreme Court, the beard has gone from black to white, and I've grown from a young man to an older but hopefully wiser man. During the past 34 years, it has been my highest honor and privilege to serve the citizens of South Dakota as a circuit judge, a Supreme Court justice, and a Chief Justice. I could not have served in these positions without the constant support and love of my wife, Deborah, and my family, Kristen, Eric, Rachel, and John. My wife, Deb, is a thoughtful and reflective person, not prone to snap decisions. Why, when I asked her to marry me, she said, "I'll think about it." I knew my response better be a good one because there was a lot riding on it. So I said, "Well, if you'll marry me, I'll promise you 2 things. One is, it will never be dull, and 2, we will never be rich." And I'm here today to tell you that I have scrupulously, and I mean scrupulously, honored both of those commitments. My bride is here today. She's back there. Deborah, please stand up and be recognized. I shall always be most grateful to Governor William Janklow. In 1986, he believed that a 35-year-old attorney from Sisseton had the potential to become a circuit court judge. 10 years later, he once again took a chance on me by appointing me to the South Dakota Supreme Court. It is my great regret that he is not alive today, so I could say thank you as I approach the end of my judicial career. During my time on the Supreme Court, I have advocated for many new programs that have come into being within the unified judicial system. For the most part, these programs have succeeded in their designated goals. In some instances, it took a certain amount of time to achieve that success. This success is due to the dedication of the people who worked on them. Without their impressive work ethic, these programs would have graced the scrap heap. As it is, many needy South Dakotans benefit from these fine programs. I trust they will continue to do so well into the future. We must, however, avoid that temptation to settle in when we make progress. The fundamental problems that they were designed to address are issues that will be with us for the foreseeable future. As time changes, our responses must also change with them. I've been privileged to work with some of the finest people I've ever met, my fellow justices, both present and past. To a person, each one brought wisdom and dedication to their position. During my 25 years on the Supreme Court, I have never seen a justice decide a case based on popularity, fear, or partisan political considerations, or conform a case to some pundit's view of a conservative view or a liberal view. They simply analyzed each case based on its facts with their understanding of the law. It is the justices who elected me to the position of Chief Justice and continue to support and elect me. They even had the confidence to re-elect me in 2005 when I was fighting cancer and offered to step aside in favor of someone with no such health problems. I've had the good fortune to work with an outstanding group of employees in the unified judicial system. They are folks that make the system work successfully. The epitaph that Andrew Carnegie wrote for himself comes to mind. On his tomb it states, "Here lies a man who knew how to enlist in his service better people than himself." I would be remiss if I did not express my gratitude for the splendid cooperation I've received from Governor Janklow, Governor Rounds, Governor Dugard, and now Governor Noem. I express to this legislature and those of your colleagues who came before you in the past 19 years my sincere appreciation for the consideration you have given my requests to improve the judicial system. Without your approval of these programs, the funding to make them work, and your support, none of this could have been accomplished. For that, you should take a great deal of pride. I am by nature an optimist. If I were not, I would have never run for the position of Chief Justice in the first place. During the very tense times of Jail for Judges campaign against the South Dakota judicial system in 2006, a jail leader declared me to be the scum that rose to the top. My wife was outraged. I told her, well, it's probably better than being known as the scum that didn't rise to the top. While I may have been slow to learn, hopefully I've been slower to forget. I leave knowing that the South Dakota Supreme Court and the unified judicial system is in good hands. Some may even see this transition as an upgrade. How well I did in my capacity is not for me to say. That determination I will leave to others, although I was greatly honored by the governor's comments of yesterday and the resolution these houses passed today. While I'm not prone to live in the past or dwell on it, I do try to learn from it. I leave with the satisfaction of knowing that there are people alive today who would not otherwise be without our drug, DUI, veterans, and mental health courts. Our goal was to swell the employment rolls, not the cemeteries. Well, time marches on. I shortly will close out this chapter of my life in service to the citizens of South Dakota for the past 34 years as a judge. Borrowing from the theme of St. Paul in a secular vein, I've tried to fight the good fight, finish the race, and keep the faith. In my time, I have striven to achieve a government of the people, by the people, and for the people, where under God, the people rule. As such, my fellow South Dakotans, this year I bid you all a fond farewell. You're welcome anytime. Thank you. I'll come through one of these days. Thank you. Thank you all. Thank you.
We want to thank Mrs. Gilbertson for joining us today as well. Thank you for being here.
Madam Secretary.
Senator Langer moves that the joint session be dissolved.
All those in favor of the motion say aye. Aye. Those opposed, nay. Motion carries. Joint session is dissolved. Let's be careful out there.
State House program funding provided by the South Dakota Bar Foundation, the educational and charitable arm of South Dakota lawyers and judges.